Is an offshore trust an effective way to hide assets from your creditors? The answer is no. Offshore trusts are not used or should not be used to hide assets. They are used to protect assets from legal process. And we have occasionally clients who expect that they could set up an offshore trust, transfer their assets to the offshore trustee, and then make the assets secret, that they believe that a creditor or court will not be able to find the assets or discover the trust agreement, and they would simply say that, well, I no longer have these assets, they're held in some trust. Well, it doesn't work like that. So the reason is that if there's a judgment against you, you will likely be subject to a deposition under oath. These are called depositions in aid of discovery, where the creditor is given the right to take your testimony about assets that could be subject or available for the creditor to collect the judgment. And in very short order, the creditor is going to discover the fact that you have an offshore trust and what assets are there. So let me just take you through a scenario where, type of questions you're going to get. Let's pretend that you have transferred an LLC interest and a financial account to a Cook Islands trust. So the creditor asks you under oath, do you own any LLC interests? And you'll say no, right? Because you don't own the LLC interest, the trustee does. Do you own any financial accounts? And you'll say, no, I have none of those. Again, truthful because they're held by the trust. But a typical question is also going to be, are you the beneficiary of any trust that was set up by you or someone else? And the truthful answer is yes. Next question is, describe the trust. Well, you may say, I have a living trust I set up for my family. And is that the only trust? No. The truthful answer is you're the beneficiary of another trust, the Cook Islands Trust. So when you testify to that and disclose that your beneficial interest, the creditor is within his rights to demand that you send him a copy of the trust agreement. Now, some of our clients expect that they'll have some type of cute answer like, well, I don't have a copy of the trust agreement. But that just is not credible. So that because when the creditor asks you further, who set up the trust, and you say, I did, and it's just not credible that you would set up a trust and be the beneficiary of the trust and no longer have a copy of the trust agreement. And yes, that could be your answer, but it's untruthful, and then you're exposing yourself to perjury. So, okay, so let's say you say, well, I'll give it to them because they can't get it anyway, you have nothing to hide. Well, so that will give them the ability to find out the nature of the trust, who the trustee is. The next question they could ask under oath is, what assets does the trust own? And so our clients will say to us, I'll just tell them I don't know because the trustee has the assets. Oh, okay, maybe that's true. But then the next question after that, and this takes 5 or 10 minutes, would be, what assets have you transferred to an offshore trust in the last 4, 5, 6 years? And then the truthful answer is you have to list the assets you've transferred. So at the end of this, and it's not a long process, the creditor is going to discover that you have the trust, discover the nature of the trust agreement, who the trustee is, and also discover the menu of assets that you transfer to the trust. Of course, the creditor next problem is how does he get those assets back to collect the judgment? But that's the beneficial aspect of the trust. It may not be possible for the trustee the creditor then to attack the trustee and trust assets. But that's not secrecy. So there is going to be full disclosure Um, Eventually, after there's a judgment against you, the creditor is going to know about this. So we recommend to our clients to simply be upfront about this and just tell the creditor after a judgment as fast as possible that you have an asset protection trust. And even before there's a judgment, even in negotiations, even pre-trial mediation, that many attorneys will, as part of the negotiation, working for the debtor, tell the creditor that even if they get a judgment at the end of a very expensive trial, they're going to find that the client, has previously transferred assets to an asset protection device offshore and is uncollectible. So the disclosure of the trust is helpful in negotiation because it'll drive a favorable settlement and maybe avoid an expensive trial and avoid an expensive collection proceeding. So what's the conclusion? The conclusion is that offshore trust should not be used to hide assets, that you should not hide the existence of the trust, rather that setting up an offshore trust and using the trust during the pre-trial process of settlement is the best use of the trust. Disclose it and use it to increase your leverage in negotiation. And in most cases, that will minimize your legal expense and get you quicker to the favorable settlement you're looking for.